Hey there. So the big news this week is that Prime Minister Justin Trudeau has said that he is going to resign. He announced on Monday morning that the caucus infighting was just too much for him and he's going to resign after a new Liberal leader is picked. In the interim, he's proroguing Parliament. Parliament is going to be on a break. And I thought it would be a good time to talk all about the civil liberties legacy of this Prime Minister. Like you, I have a lot of thoughts about this, and I can't wait to tell you all about them. If you're new here, welcome. My name is Christine, and I'm the litigation director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, hit like and subscribe below. It really helps my videos out a lot. Also, please remember that nothing in my videos is ever legal advice. If you have your own legal question or problem, please consult your own lawyer. So Trudeau has resigned, and before I get into his legacy, what do you guys think? Is his resignation good news, bad news? Would you have preferred that he stay on and be the candidate in the next election? Personally, I think that the decision to prorogue, to end the parliamentary sitting and announce that he's resigning and becoming a lame duck right as we enter trade negotiations with the US Trump administration, I think that that is, politically speaking, completely reckless and irresponsible and typically selfish of this Prime Minister. Now, if you want to hear my legal take on prorogation, I do discuss that in the latest episode of our podcast, Not Reserving Judgment. I'll link to the video to that below. So check that out and let me know what you think there. But let's talk about Trudeau's civil liberties and constitutional legacy and how I think he's going to be remembered. And honestly, on those fronts, mostly not well. To me, one of the biggest black marks against Trudeau will always be his use of the Emergencies Act. Now, I've talked about this a lot on this channel. Obviously, you are probably all familiar. Trudeau used the Emergencies Act against protesters who were upset with government policies about vaccine mandates and lockdowns. It was called the Freedom Convoy. They were protesting at different locations across Canada, at some borders, but mostly in downtown Ottawa. And police had failed to manage the protests and use their existing powers to clear the roads. You know, you can't indefinitely blockade a road, even though protesting is constitutionally protected. But instead of using existing tools and police powers to clear protests after they had dragged on, Trudeau just completely freaked out and brought out this giant hammer of the Emergencies Act. And I cannot emphasize enough just how extraordinary the Emergencies Act is. It gives the Prime Minister the power to create new criminal law on a whim. It is exactly what Trudeau did. He made new criminal prohibitions by regulation that froze bank accounts and banned certain protests. So these were protests, remember, in front of Parliament about government policy, and Trudeau's response was just completely disproportionate. The Emergencies Act exists for things like war, terrorist attacks, or massive natural disasters, not for horn honking and people carrying flags, even if they are blocking streets. That is not what this law is for. And Trudeau is the only Prime Minister ever to use this law. It is a law that replaced the War Measures Act, which was actually abused by Trudeau's father, Pierre Elliott Trudeau. And Pierre Elliott Trudeau's abuse of the War Measures Act is a big part of his legacy, just as Justin Trudeau's abuse of the Emergencies Act will always be a part of his legacy. Now, of course, a really important part of the story about the Emergencies Act isn't just that Trudeau used it, it's that he used it illegally. Now, we at the CCF brought a legal challenge to Trudeau's use of the Emergencies Act, and we won. The federal court sided with us and found that Trudeau had not met the high legal threshold to invoke the Emergencies Act, and that the regulations that froze bank accounts and criminalized protests were unconstitutional. That case is now being appealed. It's headed to the Federal Court of Appeal in the first week of February. I will be posting all about that case. I'll be doing live updates on this channel every day after the hearing. So make sure you ring your notification bell. It's a little bell icon below. If you click on that, you will get notified when my daily summaries are starting in the evenings. Now, the next part of Trudeau's legacy as it relates to civil liberties, I think will be he'll be remembered as a prime minister who was obsessed with regulating the internet and imposing all kinds of censorship on the internet. He passed a number of pieces of legislation, or tried to pass legislation, that dealt with online censorship. There was Bill C-11, the Online Streaming Act, which actually now is law. That law regulates online streaming platforms through the CRTC. It grants huge amounts of power to the CRTC, which is, of course, a group of unelected bureaucrats, and it gives them very little guidance from Parliament about how to use that power. And Bill C-11, the Online Streaming Act, requires big tech companies that offer online streaming services like YouTube, Netflix, Spotify. It requires them to contribute to Canadian content and increase its discoverability so that Canadian content is easier to find through search engines, applications, and websites. And if these companies don't comply, they can face really big penalties from the CRTC. The text of the law would really give the CRTC the power to regulate even user-generated content like this very video that you are watching on YouTube. It would basically empower these bureaucrats to put their thumb on the scale of the YouTube algorithm and require the emphasis of some types of content over others. And this raises some really serious concerns about free expression. Now, before you get too excited and say, but Christine, this should help you. You're a Canadian making videos in Canada about Canadian topics. You're CanCon, this should help you. But no, it will not help me at all. There is just so much red tape in order to get content qualified as CanCon that you basically need to be a giant company with a huge staff that can go through these bureaucratic hoops of getting the standards met. Like most content creators, I just make these videos entirely by myself in addition to my full-time job as a lawyer for a charity. So my content will never be considered CanCon under the government standards, and this law will not help me, and it will not help probably most of the users that you watch videos from. So how is this censorship? Some critics of the law have made an analogy to bookstores when describing it as censorship. Now, the government isn't banning books, but if they tell bookstores which books need to go in the front window and which need to be hidden in the back, that is a form of censorship. And that's sort of how Bill C-11, the Online Streaming Act, works. Now, the other way that Trudeau has sort of cracked down on and regulated speech on the internet is through another piece of legislation called the Online News Act. This was Bill C-18. This is the law that stripped news content from Facebook. It created a framework where what are called news intermediaries, although it actually only applied to Google and Meta, which is Instagram and Facebook, it required them to pay news publishers for links to their content. So if a link got posted on Facebook, Facebook was supposed to pay, whoever created that, CBC or the Globe and Mail or the Toronto Star, they were supposed to get money for you posting this on your own Facebook page. This was apparently to improve the sustainability of the Canadian news market because news outlets were losing money. But like the Online Streaming Act, this is all enforced through the CRTC. And I mean, it is really kind of random that the government only applied it to Facebook and Google and Instagram, but not like YouTube or LinkedIn or Twitter or X. It's just really a random selection of which platforms this would apply to. So after the bill was passed, Google and Meta announced that they would not make news content available on their sites. They were going to be blocking links. And Meta started doing it, and they still do. They block news from being posted on their platform. Canadians cannot post or consume news on Facebook or Instagram. And if you try, you get a little notification that says this is prohibited by law. And I actually think this totally undermines the news industry instead of helping it. Now, the Trudeau government was in a bit of a pickle. They were faced with Facebook actually blocking news on their platform and Google threatening to do so. And so they decided they would negotiate with Google, and Google eventually did agree to pay, but they ended up paying $100 million versus $179 million, which is what the government had wanted them to do. So is this censorship? I mean, not in the traditional sense, but as a result of the Trudeau policy, the news industry has been further undermined and Canadians have lost access to an important platform for news. So call it what you want. This regulation of the internet has resulted in speech restrictions in Canada. Finally, the last area where Trudeau was regulating the internet in a way that I think undermines civil liberties was in his proposed Online Harms Act. This was Bill C-63. Now, unlike C-11 and C-18, it never passed, and now that Parliament has prorogued, it has died. It's probably not going to come back. There's going to be an election, and I think it's highly unlikely that we will see it return. But basically, the bill was much more a traditional type of censorship than C-11 or C-18. It had 4 parts. The first was creating new obligations on social media platforms, this $200 million bureaucracy called a Digital Safety Commission that would be empowered to levy fines in the range of millions of dollars. Sometimes for things I agree should result in fines, like images of sexual abuse, but it also could levy fines for content that the bureaucrats, say foments hatred or bullies a child. And I think that this could pose some serious problems and chill speech, and it is notoriously difficult to determine what foments hatred, and bullying is also an impossibly vague definition and frankly quite subjective. Now, parts 2 and 3 of the bill had already been carved off. They had basically already been killed. These were the most censorious parts of the bill. They were new criminal code penalties for hate speech and a new civil remedy for hate speech. They were probably unconstitutional, and the government eventually did give up on them. Now, the 4th part of Bill C-63, the Online Harms Act, is a part that no one objected to. It was mandatory reporting of internet child abuse, sexual abuse imagery. And I mean, the fact that no one objected to this, and it could have passed on unanimous consent, but the Liberal government decided instead to tie this important priority to really controversial proposals in parts 1, 2, and 3 of the Online Harms Act, it kind of shows that they were actually not serious about addressing this issue. That if part 4 had been proposed standalone, it could have passed a year ago unanimously and it wouldn't have been a problem. So it is unfortunate that that part of C-63 is gone now. I think it could have helped children, but it is good that the other 3 parts of the bill are dead. And I think that Trudeau will be remembered for his desire to censor the internet in so many different ways, and in many ways actually succeeding. Now, another part of Trudeau's constitutional legacy is his hostility to the provinces and his desire to insert the federal government into provincial jurisdiction, contrary to the constitutional division of powers. And there are a number of important examples of this. The one that might immediately come to mind is the Greenhouse Gas Pollution Pricing Act. That's the carbon tax law. This law required all provinces to charge some form of carbon tax, although the feds call it a minimum national standard, and it would price pollution. So the provinces objected to this. Alberta, Ontario, and Saskatchewan brought a reference case to the Supreme Court asking for a ruling on the constitutionality of the carbon tax, and asking whether the feds had waded into their jurisdiction and were telling the provinces what to do. The provinces said that they have their own policies tailored to their own circumstances. They have their own environmental policies, and they also have jurisdiction over natural resources. But the court, unfortunately, sided with the federal government and found that the policy was not a tax and that Parliament had jurisdiction to set national minimum standards under the Peace, Order, and Good Government Clause of the Constitution. But since then, the Trudeau government has given an exemption under the Greenhouse Gas Pollution Pricing Act for home heating oil, which primarily benefits East Coast provinces, and this was an intentional decision to shore up votes in that region. And it reveals, I think, what many of us suspected all along, that this carbon tax, and yes, I will call it a carbon tax, it is a political tool that is not, in fact, really about national minimum standards and is therefore outside of the authority of the federal government. Another example of Trudeau's legacy of federal overreach is something called the Impact Assessment Act. And this is commonly referred to as the No More Pipelines Law. Basically, the way the Impact Assessment Act works is if someone wants to do a new project like a mine or a oil development project, things that are traditionally regulated by the provincial government, even if it's entirely within one province, under the Impact Assessment Act, they have to undergo this really lengthy and comprehensive federal environmental assessment. It reviews projects on this completely ridiculously wide range of economic, social, health, environmental, and even gender-related impacts. So, like what is the gender impact of your mine or of your oil development project? Now, ultimately, the Impact Assessment Act gave the federal government authority to determine whether and on what terms projects would proceed in Canada. And this was very frustrating to Alberta, who, a lot of these projects are entirely within the boundaries of one province. Most of them are just within the boundaries of one province. So Alberta launched a constitutional reference asking about the constitutionality of the Impact Assessment Act in 2020. And the case went all the way to the Supreme Court. We intervened in that case, and Alberta won. It was a 5-2 decision, and the Supreme Court held that the vast majority of the Impact Assessment Act was unconstitutional and that Parliament plainly overstepped their constitutional competence by purporting to regulate projects that otherwise fell within provincial jurisdiction on the mere basis that they could have effects within federal jurisdiction. The case was a major victory for the integrity of our constitutional division of powers and a clear message to the Trudeau government to stay in their lane, which, of course, they didn't do. They also tried to use the criminal law power to regulate all plastics. In April of 2021, the Trudeau cabinet issued an order placing all plastic manufactured items on the list of toxic substances in Schedule 1 of the Canadian Environmental Protection Act. So alongside chemicals like mercury. Your hard hat that you wear to work is of the same danger, apparently, according to the Trudeau government. So following this order deeming all plastics toxic, a group of plastic industry companies applied to the federal court for a judicial review, and they argued that this labeling of all plastics as toxic amounted to a plastic ban, and it was unreasonable and unconstitutional. And the federal government had used the criminal law power to regulate these products. And as I said, that they can do that. Lead and mercury can be treated using the criminal law power because these are, products that actually can be quite toxic and have really clearly identifiable dangers associated with them. And listing products like that as toxic substances under Schedule 1 of the Canadian Environmental Protection Act, that's been upheld as well. It's as a valid use of the federal authority. But the criminal law power is not like a magical incantation. Invoking the words criminal law does not transform any topic, any subject into something that Ottawa can regulate. They can't just say, oh, now it's criminal law, so we have control over it. In this case, the criminal law power should not be allowed to justify the sweeping inclusion of every imaginable plastic product on the list of toxic substances and therefore under federal authority, just because Trudeau says so. So the Trudeau government lost at federal court. The case is now under appeal, though, and we intervened in that appeal. I think another area where Trudeau will be remembered is for his rapid expansion of medical assistance in dying, or euthanasia. Now, I did a whole video explaining medical assistance in dying and euthanasia and how much things have changed, but I'm not going to repeat everything I said, but basically there was a decision called Carter that came out in early 2015. That was actually when Harper was still Prime Minister, but it was suspended for 12 months So the ruling essentially came into force when Trudeau was Prime Minister. And things went from a prohibition on euthanasia in 2014 or early 2015 to where we are now, with a plan to expand euthanasia to allow it to be for people who are suffering solely from mental illness. And it's led to some of these truly horrifying stories that I cover in that other video, and which I'm sure you've heard repeated elsewhere. Now, let me be clear, the Trudeau government, when the Carter case first came out, they did originally have a pretty reasonable plan for MAID and euthanasia. The Trudeau government's initial response to the Carter decision was a piece of legislation called Bill C-14. This was when Jody Wilson-Raybould was the Justice Minister. Under C-14, MAID, which was introduced in 2016, MAID would be limited to patients suffering from incurable illnesses whose natural deaths are reasonably foreseeable. But since then, MAID has expanded. In a case called Truchon and Canada from Quebec, the Quebec court found that the law was unconstitutional for restricting euthanasia to those whose death was reasonably foreseeable. But instead of fighting this, the case was not appealed and things just escalated, and here we are. Now, as I've said before, I'm not a conscientious objector to all euthanasia, but I am troubled. The speed at which things have been expanding is concerning. We've all heard these stories of pressure and coercion on elderly, vulnerable, and disabled people. And Trudeau's plan for euthanasia for mental illness is really disturbing. I mean, I have friends who have battled depression and even attempted suicide, mercifully unsuccessfully, and they're now happy and healthy with beautiful families. And if euthanasia had been available to them at their lowest points, they tell me that they would have taken that option. And that's terrible to offer that to someone who's so vulnerable instead of offering them care to improve their lives. And I think Trudeau is going to be remembered in large part for this. Another thing I think Trudeau will be remembered for is his unbelievable hostility to firearms owners. Since 2019, Trudeau has really accelerated restrictions on firearms in Canada. In 2019, he promised to ban what he called assault-style weapons. And then in 2020, he announced a ban on 1,500 of such assault-style weapons effective immediately. In November of 2022, he announced a move to ban hundreds of hunting rifles with a list of banned guns that ran more than 300 pages. Now, he did withdraw this in February of 2023, but his plan was to ban many weapons that are used for hunting, used by farmers, and that are perfectly should be legal firearms. Now, the ban on those 1,500 weapons was challenged in federal court by the Canadian Coalition for Firearms Right in a case called Parker in Canada. They were unsuccessful, but the case is now headed to appeal. And I think whatever the result in that case, Trudeau is going to be remembered as very hostile to firearms owners. Now, I do want to recognize a part of Trudeau's legacy that I think was a positive development for the law and for civil liberties, and that is the decriminalization of marijuana. Now, I don't use marijuana personally, but I don't think that people who do should go to jail. And decriminalizing it is extremely reasonable, I think. Now, it is an open question. Would decriminalization have happened without Trudeau? I think probably. I mean, a number of US states have removed state criminal prohibitions on marijuana, and it probably would have happened in Canada under any government by this point. But it happened under Trudeau, and I do think that that is a positive part of his legacy. But what do you think? Is there anything that you think I missed from this list? How do you think Trudeau will be remembered? Leave a comment below and let me know. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.